Hello friends, I'm Sharon Abaud, immigration attorney, here today to talk to you about what to do if you are married to a U.S. citizen and you are in the process of separating or divorcing, and maybe you just think that's it, that you have no hope that's it. Listen, stay tuned, because there may still be a chance for you. You want to listen to this. Before I get started, I want to go ahead and remind you all to please subscribe to my YouTube channel by clicking the bell below. That way you will receive notification every time I upload a new video. Today we are going to talk about two different ways that you may still qualify to get your green card even if you are separating from your spouse or divorcing. One, the first thing to note is that it's important to know what stage of the process are you in. Did you ever file? Do you have perhaps you already have the 2-year green card and you were about to file to lift conditions when the separation occurred? Perhaps you never got a chance to file. So depending on what stage you are, there may be different options for you. First, let's talk about your options if you already filed and you have your 2-year green card and you are waiting to apply to lift your conditions, otherwise known as the application to lift conditions form I751. If you are in the process of filing the I751 or you didn't get a chance to, you may have 3 options. The first one is that if you actually finalize your divorce, you can file to lift your conditions alone. It's called an I751 Waiver, by showing that you got divorced and that your marriage was bona fide at the time it had been entered into. So you will have to show that your marriage was real or valid at inception, and you will also need to show that there was an actual divorce. The second way that you can file to lift conditions on your green card without your spouse would be to show that there was some form of abuse or extreme cruelty. This could come in different ways. Perhaps there was physical abuse, you were physically abused. Perhaps there was a police report. Perhaps there wasn't. If there wasn't a police report, you may still qualify for this. So it's really important that you talk to a legal professional about this option if you think this pertains to you, because a police report is not required to qualify this way. Again, this form of abuse or extreme cruelty can come in many different ways, and I'm just here to give some examples. Every case is very unique, and again, I emphasize to please consult with an immigration attorney about this option. But some ways that you may qualify through this manner is by showing that there was extreme cruelty. Perhaps you were in a relationship with someone who was extremely possessive or manipulative, jealous, and they showed that these characteristics in very abusive type ways. So perhaps you weren't allowed to leave the house. Everything you did, you had to ask for permission, couldn't talk to people of the opposite sex or same sex, depending on your situation. All of that varies. So these are examples through which you may be able to obtain a waiver for the filing to lift conditions so that you can get that permanent 10-year green card on your own without your spouse. The third way would be to show extreme hardship. And again, all of these 3 ways, I recommend you definitely want to consult with an immigration attorney and have the representation and guidance of an immigration attorney throughout the process in this unique type of case. In the other situation, perhaps you never got a chance to file. And I've spoken to a lot of people who got married and then, they were married for 3, 4, 5, 6 years and no one ever filed anything for them. And a lot of the times when I ask what happened, it's that the spouse always kind of used it to manipulate them. And then when I go a little deeper, I find out in these conversations that there were other types of manipulation tactics and forms of threats and manipulation that come in many different ways. And it is then that I determine, whether this person qualifies for VAWA. A lot of the times they do. So it's really important to keep that in mind. If you even think you may qualify, it's worthwhile to consult and have an evaluation on your case to see if this is an option for you. So in these types of cases, if you've never filed anything before, and even if you filed before and your case was still pending, this may be an option for you. But if you've never filed, or you filed and just never had your green card, VAWA may be an option for you if you were in a abusive relationship. And the reason I'm careful with the word abusive is because people tend to think that abuse only comes physically, and there are other ways that abuse can be shown. Abuse can be psychological, emotional, financial, and they just come in many different ways. And so again, if you think you are in such a relationship, I really can't emphasize enough for you to seek an evaluation from an immigration attorney, whether it be me or another immigration attorney. Please consult about this because it may be the light at the end of your tunnel. So I can't emphasize that enough. So if you do qualify for this, you may have an option to file VAWA and at the same time file for adjustment of status. You would be able to have a green card within about 2.5 years and a work permit and travel permit in 6 to 8 months. Again, every case is very different. Some cases require waivers. Some cases, you won't qualify for a green card, but you can get protection against deportation and a work permit. Every case is very unique. So again, please consult if you so much as think that you qualify. And I want to emphasize this more. If you are in the process of getting divorced, don't wait. Do not wait, because if you do qualify for VAWA, there is a deadline. You only have 2 years from the date of your divorce to file this type of case. So I hope that I gave you all some really helpful information. I know that if you're watching this video and you feel like I'm talking to you, you're possibly not in a good place right now. I hope to be giving you that light that you need, that ray of hope that you need to know that you may have a way out. The first step is to take that initial step and have a consultation and ask questions about your case. Your case matters, so give it the time that it deserves. I'm Sharon Abaud, immigration attorney. Don't forget to subscribe to my YouTube channel so that you can get notifications when I update you with more videos. Thank you so much.